John and Ken Show. John Cobell and Ken Champeau. More than a decade ago, the sleazy, slimy lawyer industry bribed the sleazy, slimy legislature
for something called PAGA, P-A-G-A, which stands for Private Attorneys General Act.
It allowed normal lawyers to act as if they were an attorneys general.
Yeah, attorneys general. That's multiple.
And sue employers for really minor, piddly mistakes that they made in running their business. You could use the law for clerical errors, but then you could multiply that clerical error across dozens or hundreds of employees.
In 2016, more than 5,000 of these complaints were filed. Even the Humane Society got hit with one. The Salvation Army. It says here even one of Gavin Newsom's own companies, Plumpjack Management Group, I guess that's the wine stuff, they got hit with one of these suits.
Plumpjack?
Plumpjack. Yeah,
Newsom's company is called Plumpjack?
Yeah, I think that might be the name of one of the wineries, or I don't know.
That sounds a little suspicious.
So a bunch of law firms have been doing this, and of course, as John mentioned, they favored this legislation to give them a chance to go out and just file suits against companies. We're going to find out more in the specifics. And
well, we'll give you one example of how this works. In October 2018, attorneys settled with Walmart, and the attorneys got $21 million, and the employees got $108 each.
Oh, no.
And there's many other examples.
Yeah, there's another one with Uber, another one with Google.
Tom Manzo is the founder of California Business and Industrial Alliance. Tom, how are you?
Good. How are you? Thank you so much for having me on. I really appreciate it, guys.
Give us an idea of what's typically in these lawsuits, these complaints against these companies.
A majority of them are over late lunches. And then once they have the ability to go in and look at payroll records and data, then they find a lot of other things. And they look for other things. They'll name anything and everything to find the wrong thing. You know, are you rounding up or rounding down your hours when you punch in correctly? What about commission agreements? What about vacation time? Is that properly on the paycheck? Bonuses. If I give somebody a gift card, was that calculated properly?
So it's a big fishing expedition to find
errors or things that are overlooked.
Absolutely, absolutely. And a lot of people don't know or they don't understand, some of these things. I mean, a lot of companies, smaller companies like to have a flexible work schedule. There's nothing wrong with a flexible work schedule. People work together. They like to eat lunch together. So, but if somebody takes their lunch past 5 hours, that's a labor law violation. And what ends up happening is you'll employee an hour's pay for the lunch. Then if the paycheck was wrong, the first paycheck is a $100 penalty. The second one is $200 per paycheck from that point on. And, before you know it, all of this stuff starts to really add up, and you're into the millions of dollars on these suits.
Right, and the attorneys walk away with most of the money.
Well, here's the funny part. So if there's a lawsuit, and take you mentioned Walmart, for instance, and if you read the complaint, it's disgusting because they act like they're pioneering this legal fight and this battle, and they've done whatever they could to help the employees have a stool there if nobody is standing in line and the cashier can take a break and sit down. So that was $65 million fine. That's
wait, $65 million because companies didn't have a stool?
Correct, next to the cash register. If a customer wasn't coming through...
Well, was that was the Walmart suit?
That was the Walmart suit.
$65 million because Walmart didn't provide a stool for the cashiers.
Yeah.
And the attorneys in this got the $21 million?
Well, here's the thing. If you read the complaint...
I guess that's about a third.
It's hysterical because they say that the total exposure of this lawsuit was almost $500 million. So it was over $500 million the exposure, and they told Walmart, I think this is a good deal. This is a good deal for you. It could have been way worse, and we're providing money to the state now.
These are shakedowns like
this
the other
sounds like Trevor Law Group from years ago, right?
These are all
operating like
shakedown stories where they come in.
You come in and settle. It'll be worse for you.
And the companies settle because it's much cheaper than even going to court and winning.
You can't go to court. You will lose, and these are beyond shakedown lawsuits. I mean, you're talking millions of dollars. I mean, it's not like the ADA type lawsuits where somebody comes in, you got to fix something. Hey, pay the guy $5,000 and they leave. This is a situation where you're paying millions of dollars.
Explain to me what was the requirement for the stool?
So they can sit instead of standing during their whole shift. If there's a downturn in business, they get to sit.
But that's a law? That's a requirement?
It's in the California Labor Law Digest. It's 1,100 pages. Most people don't understand it.
So it's in the law that you have to provide a stool to a cashier so they don't have to stand the whole time?
Correct.
Yes.
Correct. We have a member. We have a member that has got a great company, and people were making good money. And they had kind of what you would say part-time and full-time salespeople. And the part-time people loved what they were doing. And they had a disgruntled employee. They went and talked to an attorney. They did not have a written commission agreement. And there were some commissions that weren't calculated correctly. And when I say not calculated correctly, guys, I'm talking you're off pennies. And it ends up costing millions. It cost this particular member $2.5 million because the commission agreements weren't written correctly.
It's always the crazy employee that causes all this trouble.
You know,
I mean, you could treat 200 people right, and there's one guy who's got some bug up his rear end, and he turns it into a huge case. The crazy people ruin everything for the normal people.
Absolutely, but going back to the PAGA case, the Walmart case, which is really interesting. So everything's negotiable. What the employees will get in the settlement is negotiable. What the state gets is negotiable. What's not negotiable is what the attorney who is suing you gets. They get 100% of their pay because that's the deal they made with the state back in 2003.
It doesn't do anything for the employees. The employees only got $108. Look at this one.
They got a stool.
January 2018, they settled with Uber. The lawyers got $2.3 million. The drivers got $1.08.
$1.08 each, and nothing changed.
And
what difference did it make? You know, and
what was the violation against Uber?
Well, because they had the employees misclassified. This is another big battle that's going on between independent contractor and actual employee. So if you're driving the Uber full-time, really you should be a full-time employee, not an independent contractor.
That was the claim against Uber.
That was the claim against Uber.
But the employees, the drivers got $1.08 out of it.
Yeah, here's one that you'll really like. There's a law called de minimis law, and Starbucks decided to fight it because they had an employee that was the manager of the store. He would clock out. He would then go shut the lights out and lock the door behind him. And if he had an employee or two with him, they would all walk to the parking lot together and go home. Well, the attorney said, well, wait a minute. He should be getting paid from the time that he clocked out till the time he walks to the parking lot with the other two employees. So Starbucks fought it, won, and the attorneys fought back. They won. A judge in California overruled it. The amount of time that was owed to this person over a period of 4 years was $670. $670.
How would a lawyer?
But the lawyers did well, I'm sure.
But how did the
upon millions? Yeah.
Can you hang on, Tom?
Yeah.
Hang on.
We're with Tom Manzo, founder of something called California Business and Industrial Alliance. We've had him on the show before. He's the president of Timely Industries in Pacoima. But what he and his group want to do, they want to end something called the Private Attorneys General Act. If you're a longtime listener to the show, this is similar to the Trevor Law Group from years ago, where they're looking for picayune violations, which they want to blow the fleas up into elephants and get these companies to settle so that there's good fees for the attorneys involved. Not a lot for the complainants. He was talking to us about a Walmart case where apparently they were not providing enough stools for the cashiers to sit during their long shifts, and it resulted in a $21 million payday for the lawyers and $108 for the employees involved.
No wonder everybody's always yelling about their break when you go to Ralph's. Did you take your break?
Why.
Yeah.
That's exactly why.
All right, hang on, Tom. More coming up. John and Ken Show. John Cobelt, Ken Champeau, KFI, AM 640. We're going to talk more with Tom Manzo. He's the founder of the California Business and Industrial Alliance. They are taking on all the slimy lawyers.
Oh, the trial attorneys. They got their way with something called the Private Attorneys General Act, which was passed more than a decade ago by the state legislature. And it has taken a toll on businesses. It's really another example of petty issues that these lawyers go after, dealing with work rules, regulations, and things like that. And basically what they do is they find a few employees to represent, but they take home the big paycheck.
They take millions, sometimes tens of millions, and the employees will take $100 or sometimes $1 out of the settlement. And it's payroll, clerical errors.
Stools that are not provided for Walmart employees who have to stand up. And
let's put Tom back on. So what is your organization doing? What action are you taking?
Well, we tried the legislative approach this year, and we thought we had a bill that might have some potential to it, and it didn't end up working out. And what we decided is we said, it seems like a ballot initiative's a difficult route. It seems legislatively we're going to have a hard time working with labor, and we're going to be fighting the trial attorneys. Let's really sit down, strategize, and think about it. And we put together a lawsuit, and we're suing the state of California, and we named the Attorney General in our lawsuit.
And what's the basis of the lawsuit?
Well, we're questioning the constitutionality of PAGA, and it's a 54-page complaint. And the funny part is, and this is really important to know. So the synopsis, our opening sentence says, our California business owners who inadvertently make payroll errors equivalent to the worst perpetrators of hate crimes. That's the twisted logic that more than a decade ago led to the state legislature to pass a harmful law called the Private Attorneys General Act. Now, we started digging through, and we did research and data and information, and believe it or not, when they were sitting there ready to pass the bill, they said, well, how do we come up with the structure? Well, let's use the same as hate crimes. So a late lunch is equivalent to a hate crime in the legislator eyes back in 2003. And it does not surprise me, because the guy behind it, his name was Joe Dunn. Are you guys familiar with Joe Dunn?
Yeah, I remember Joe Dunn, right, a legislator.
Yeah, legislator, great guy, right? So what did he end up doing? He ended up passing a law and really giving the trial attorneys, a wonderful payday.
Yeah.
And here's the gun. Go and rob every business you can. And what's funny is, if you look into Joe Dunn, he worked for the state bar, and he ended up getting fired. He got fired because he was going on lavish trips and things like that.
Oh, one of those guys.
So you got Joe Dunn, you got Gray Davis, and what did they end up doing? They gave a present to all of these trial attorneys.
Yeah, this is the corruption that goes on 1,000 times a day in Sacramento. I'm sure they got big donations from all the trial lawyer interest groups.
I mean, this is like a billion-dollar, multi-billion-dollar cottage industry.
Yeah.
That a lot of people just aren't familiar with.
What's the constitutional argument you have, though?
Well, the constitutional argument is there's several different things in here. I mean, we have 164 different items, but in reality, so the law was brought on in 2003 because there was a budget deficit. So they didn't have any money to enforce the labor laws. Because they didn't have money to enforce the labor laws, they said, let's let the trial attorneys do it, and in exchange for them enforcing our labor laws, we'll make sure they get paid 100% of whatever they're owed. So that was the deal. Well, today, there's a budget surplus. Why are we allowing trial attorneys to enforce labor laws? It's not allowed in any other state of the union. Nobody else does it, only California.
But is that a constitutional argument, though?
It's a constitutional argument, yes.
That the state can now take this back and do it themselves?
Yeah, take it back and do it themselves.
Well, but I mean, they've been doing it for 15 years.
I don't think anybody's challenged it in a way that we have decided to challenge it. I think we're one of the first organizations to say, enough's enough, and we are going to file this complaint, and we are going to put as much in there as we can so people can read it and understand it. I mean, it's devastating to anybody that's been in it. We have 181 key points in it, and there's a lot of things.
But there's something in the Constitution that prohibits the state from contracting
delegating this. Yeah.
Well, there was a case, the Ascanian case, and the Ascanian case said they compared it to key tam, and key tam is pretty much if you have a government agency overseeing such a case, they have to have involvement. They can't just walk away from it. So Ascanian really didn't do their research, and that was a Supreme Court case, and that's part of this complaint. So what happens is the state will send out a notice, a PAGA notice. A lot of times the employers don't even get it. Once that happens, the state has no idea what happens until the money from the settlement gets put into their account. There's literally no involvement. In key tam, the state needs to be involved. The state should be at mediation. The state should be at the judge where the hearing is. The state should be there overseeing the entire case. They're not. They're not doing it at all.
All right, Tom.
Keep us apprised. We're just out of time, but we're definitely on your side. We want to know how this goes.
Well, here's the one thing. If anybody can look at our website, CABIA.org, go on there, take a look at it. The complaint's on there. Join our cause. One thing that you two guys are going to love is next week we're going to start going on a little tour, and we're going to go out and we're going to start protesting and picketing in front of the attorneys' offices that have been suing all these businesses.
Oh, great.
Right, set some cars on
join
fire.
the tour.
We look forward to that.
All right, Tom Manzo, founder of the California Business and Industrial Alliance. John and Ken.